Good morning, Adab, Sat Sri Akal. Now this video will be exclusively for the Kalsia state or where Ambala cantonment fell. Now how documentation and how did the gazetteers and everything said that how land records have to be maintained and what was the procedure. So this Kalsia state 1904, a document which came to us, the measurements were made here as Kotla on the basis of the scale of 40 kadam circle. So do you know kadam means that you used to measure your step. Were the scale and had to be doubled on account of the minute subdivisions of fields. The cultivators were as a rule entered as proprietors of their land in accordance with the commissioner's orders contained in the letter number 183 of 23rd April 1888 and then approved by the government. So let's presume that till 1888 in Kalsia state there were no settlements which were being done. Let's take the reverse order of this letter. Till then 40 kadams had to be measured and that's how these grants or old grants had to be converted into new grants. Now we'll talk of another gazetteer which came in our hand, that is Ambala Gazetteer 1882. It vary in the chapter Village Communities and Tenure in a table called 15 shows the number of villages held in various forms of true owners as returned in quinquennal table of 33 of the administration report of 1879. But the accuracy figure, it says, was doubtful. It is in many cases simply impossible to class a village satisfactorily under any one of the ordinarily recognized tenure. Now, what are these tenures which they are trying to tell? When these villages were being settled or settlements were taking place, the primary divisions of right between the main subdivision of the village of one form, while the interior distribution among several proprietors of each of the subdivisions. So Ambala was being made out of how many villages? We know one case called the Babayal. We know another 17 villages like this. So the Zeldars or the chiefs, headmen, which were appointed by the district officer, so there were about 5,164 villages headmen in this Kalsia state or Ambala. These villages headmen succeeded to their offices by hereditary rights, subject to the approval of Deputy Commissioner. Now earlier, remember I had said what were the 4 rights of how proprietorship could be. So hereditary rights were there with the headmen, but by the approval. There were numerous such portions of amount of land revenue which represented in this district for individual or several proprietors. Now another table which shows the number of proprietors or shareholders and a gross area held in property under each in the main form, and also gives details of large estates and for government grants in similar tenures. What are these government grants of those people who were proprietors of their land? One needs to understand. And the tenure period was only changing to what? The figure was taken by an administration report made in 1879. Again here, the system was little objectionable. You know, Punjab as a whole, the people in this area were very fanatic or very attached to the word called land. Land was like a mother to them. So the settlements, whether of a tiller, whether of an original zamindar or a pattidar, was little tough. The number of talukdaris or intermediate tenures in the district is unusually large. This is a gazetteer speaking. They are locally known by the name Biswadari and are of that kind where a fixed allowance is paid by proprietors in possession of land in recognition of superior proprietary in the possession of these lands. in recognition of a superior proprietary rights existing in other whose possession has fallen into abeyance. Now, who were these superiors? They were the zamindars. Who was the inferior proprietary writer or occupier? That was the biswadaris. There are no less than 691 such holding in the district. A large number than is to be found anywhere in the Punjab. Now we are talking of Ambala district. Except for the divisions like Rawalpindi, Multan or Hoshiarpur, this district, the tendency of Sikh system was to strengthen the hands of actual cultivators of an estate. Even the Maharaja Ranjit Singh or the other Sikh rulers in this area. The method of realizing their revenue at equal rate forms all whom they found in possession, without regard to the nature of their tenure, tended to reduce and to a great extent did reduce to a dead level almost all these distinctions between proprietors and non-proprietors. So even the Britishers accepted the original format of the Sikh rulers, that the tiller was considered to be the proprietor because the yield had to be taken from him, the produce. So they said this will be a more better level than to create something. So the cultivators, after paying the share of their produce demanded by the Sikh masters, had nothing left with wherewith to pay rent, nor was there any owner to compete them to pay it. So, see, once you've given your produce to your ruler, how would you pay rent or lagan to the property? Thus, many who under Mohammedan rule had enjoyed the right of lord of the period of their power, they had retained in actual possession a few acres of land for their own cultivation. These they continued to hold, paying revenue to Sikhs on equal terms with other cultivators. But as a manorial right on the other lands, they retained none, but such as form customs. These cultivators were left on their own free will. So, if you were not tilling that grant given to you, the original owners actually gave in to the tillers or the occupiers. Village communities, when the settlements were being taken from north to south, the rights were restricted to proprietary of that landowner. But when the original British settlements, these ousted landlords attempted to assert their long neglected claim. Now, the zamindar was the owner or the proprietor or the grantee from the Sikh ruler. He was willing to only cultivate the land which he could cultivate. The balanced land which was being tilled by another person, he left it to him. So now when this attempt was being done, the officer who effected the settlement of the southern portion of the district was an advocate for their recognition, either by actually making the settlement with them as proprietors, or where this was not possible, by assigning them an allowance under the denomination of Biswadari. So what was the settlements were being done? Okay, fine. You cannot be called a proprietor, but we will call you a Biswadaris. Now, their claim was to, actually the British claim was to engage them to revenue. So, where would this extra Biswadari or this allowance to that Biswadari come from? Such cases were mostly settled by arbitration. But no doubt the basis of settlement officer contributed in a certain degree of enhance the number of those who obtained recognition of antiquated rights. The officer who conducted these settlements of the northern Tahsil of Ambala, on the other hand, was of the opinion that in the majority of cases, the superior rights of such original proprietors had fallen too completely in abeyance to admit of their recognition, and his policy was to maintain as proprietors of all those who were found in proprietary possession. granting an extra Bissadari. So friends, what I have been telling, we were old grants. Gradually, how sovereignty travelled. This is very clearly explained in this gazetteer. Biswadaris were made proprietors because the British were looking for revenue. That's all what has to be discussed. We have to just understand this. There was another gazetteer of Ambala which came in my hand, that was in 1925. Now it has even in that gazetteer mentioned how many Zagirdaris, Pattedaris or Zeldaris. The numbers have been mentioned. 2,97,159 rupees were collected from these many Jamindars. The Pattedaris were paying 2,80,258. Zeldaris were paying some smaller amount. So nothing goes to the government. Even after the death of any is forbidden to take rights. This is what the Imperial Gazetteer was saying at some stage. As long as the descendant remains hairless, share passes to the remaining member of the family and not to the government. So it is so clearly written that hereditary rights were there in these grants. Majorities of the cases, sometimes in those days you did not have issues. So a joint family used to be finally the inheritor, which you today may call it an HUF. So this is how the whole table grows. Now when the settlement rights were being defined in 1915-20, an Appendix 3 was a final report was made for Ambala district. The reference was taken from Mr. Whitehead, final settlement report of Ambala, which says on para 100 and 127 of the Punjab Land Administration Manual. He is again bifurcating these four classes of Jagirs. Major Jagirdars, Pattidar Jagirdars, Zaildars or subordinate feudatories of the Jagirdars, or war Jagirdars, or Pattadari Jagirdars are the descendants of Jagirdars who were given the status in 1809 and shares the Jagir in Pattis and collectorals, the collections by the district revenue officers, inheriting from shares dying without issue, provided in any common descent a family is there. So these rights were given to them. In 1925 also the British and the gazetteers are admitting. Where is then the problem of saying? Now there was an example set in Ambala, and this example was the making of the record of rights done by the British government for one cantonment. It started for Rangoon, but it actually was made in Ambala cantonment. Now what does this Ambala cantonment? The record of rights, the cantonment magistrate Mr. Campbell clearly says he found no records of grants. The actual portion, there were about 170 plots which were under private buildings, and this was outside bazaar limits. 1910, outside bazaar limits is the record of rights speaking. So that means there was a bazaar area. He said class first was 17, class second was some 18 and class 3, and about 112 he found no records. So what are these classes? Class 1, class 2, class 3, there were records, that means, of these bungalows or of these properties. Government only wanted its specific rights to resumption. See, please understand what this word resumption is spoken in the GGO and now in record of rights. I attach a copy of a memorial annexure Q. I have interviewed a number of these memorialized and have discussed this situation with them. The vagueness of the entries alarm it. They do not seriously dispute the ultimate proprietary rights of government, but they wish an entry to be read to the effect that they have the right of perpetual occupation. That circumstance, that on eviction, they shall be paid compensation for their right of occupation of the soil in consideration of the length of time that they have enjoyed this occupation. And under no circumstance can government impose upon them any ground rent which is to be fixed. So we were asking that in 1909 with the record of rights being made that we will not pay any rent because we were revenue free grants. I have explained that I have no authority either to enter any right that is not proved to exist or to negotiate on behalf of government. See, it's so clearly Campbell is saying this. And they have, I think, understood my position. With regard to para 2, I have found no authority, acknowledgement on behalf of government anywhere that house owners or our landlords of more than their own building. The precise legal meaning of the term landlord and the Office of Evidence Act are questions of court to discuss. So record of right was basically leaving this. I found, he said, 2 applications for grant. The dates were previous to 1850. There was no other case. So limitation law was being applicable, he says. Now after 1850 to 1910, you cannot ask for a application for grant when you are already in possession. There is little doubt that the house owners, we have been allowed in the past to transfer our only rights as though they were the absolute property without any interference of the local authority. Most of the owners in 19... So what does Campbell believe? He said an arrangement can be arrived at between the house owners and a commission specially empowered to evolve a statement of the rights of the government is prepared to recognize as belonging to the present holder of unrecorded grant. This is very important. This is very important what Campbell says. I fancy that government wants no more than the power to resume if an occasion rises or the military requires that. It would be worthwhile conceding something to obtain a definite settlement of the relation between government and the occupier of a building site in the cantonment as circumstances are. This cannot be secured by directing the preparation of a mere record of rights. I don't know how people fight their cases, how Babyal people fought their cases. So where in Annexure Q, Campbell says Assistant Collector, First Grade Ambala, with reference to the House Proprietors Ambala Cantonment regarding proposal to prepare a record of rights for the private estates in Ambala Cantonment, following the draft, to submit that the government has no proprietary rights in plots of land built over or in the compounds of any private bungalows situated in Ambala Cantonment. Friends, wake up. You may be having record of rights for your Mau Cantonment or your Sikandrabad Cantonment. 57 cantonments, do they have record of rights? Or were record of rights made minus your cantonment? Please dig into these records from your archives libraries. Once again, I am saying, we were old grants, never converted into new grants. Thank you. Good day.